Thank you, Mr. Chair. To the witness, would you support amending the Conflict of Interest Act to provide for an enforceable general anti-avoidance measure so that anyone who circumvents the act by exploiting a technical loophole or concocts a scheme to get around the act and its application entirely could be held accountable?
So GAR rules are in place in many other statutes in Canada, starting with the most important one, which is the Income Tax Act of Canada. Okay, so those types of rules have been used effectively to do exactly what you are looking to do, which is to avoid the ability for individuals to design legal mechanisms to avoid taxation. Now, avoiding taxation and delaying taxation are two very, very different things. So now in this particular case, if someone is creating a construct that would allow them to advance a private interest, I think this goes back to the question from Mr. Terrio. Like, that's an ethical question, not a legal one. It would be interesting to see what that rule looked like. Certainly, I would be happy to comment on a rule once it's been designed, but a general anti-avoidance rule in this area, I think, undermines the whole purpose of the Act. Like, anyone who's willing to design that kind of a tool to avoid the application of the Act, they're going to find another way around it.
I would cite one example. It's one we faced last fall when Mark Carney, before he became Canada's most conflicted Prime Minister, was appointed as, for all intents and purposes, Justin Trudeau's economic advisor. Now, as the Prime Minister's advisor, Mr. Carney should have been subject to the Conflict of Interest Act. However, Mr. Carney and Mr. Trudeau effectively cooked up a scheme whereby Mark Carney was not technically in the PMO, but instead supposedly housed in the Liberal Party as the so-called chair of the Liberal Party's task force on economic growth, as it turned out to be nothing more than a one-man task force. Mr. Carney, also that Mr. Carney could avoid accountability, skirt the law by getting around the Conflict of Interest Act, and hide his multitude of conflicts of interest from Canadians. It was a complete and utter sham. Everyone knew that Mr. Carney was advising Justin Trudeau. Justin Trudeau even bragged about the fact that his economic advisor was none other than Mark Carney, and yet Mr. Carney was circumventing the Conflict of Interest Act. Do you not see a problem with that scenario?
So the Conflict of Interest Act applies to people who are actually in office. So if that was an actual office that was paid for by the Crown, I think we'd be talking about
it would
something
apply
very
to
different.
an aide to the Prime Minister. It would apply to a ministerial aide. It would apply to a
They're
ministerial advisor. Mark Carney was effectively
employees.
in that role, but yet he was able to avoid the Conflict of Interest Act. Hence the need for some sort of mechanism to address it, in my view.
Okay, so the Act applies to public office holders, and it applies, the various codes apply to the individuals who are governed by the code.
The whole point, and the whole point is to address those who are taking advantage of a loophole. Here you have the CEO of a $1 trillion investment firm advising the Prime Minister, someone who has all sorts of conflicts of interest, and yet was able to get around the Act. Yet, had he been in the PMO doing exactly the same thing that he was doing outside of the PMO, he would have been subject to the Act.
So I'll say two things in reply. The first thing I'll say is you're quite right to make these concerns known if you think that they are important to you and your constituents. I think that things that happened in September 2024 had a pretty good litmus test subsequent to that. So you say that this was something that was common knowledge and everybody knew it. Well, if it was common knowledge and everybody knew it, I guess that factored into some decisions that people made at a later date. The second thing that I would say is there's a difference between going around something and having it not apply to you at all. And I think that it would not be a good idea to have an act apply to people who are not in the public service. Okay, so you may call it a circumvention, but the threshold is whether or not they are in the public service. Now, I am not privileged to any information that may have been shared between the two individuals that you mentioned, but certainly there are other people in that office.
10 seconds, Mr. Thorold.
Other people in that office who understood what those arrangements were. I go back to the comment made by Mr. Theriault. It's about what the moral compass for those individuals is.
Thank you. Thank you, Mr.
Minutes.
Cooper. Ms. Church.
Well, maybe there's a difference in terms of the introduction of appearance of conflict of interest. In terms of the notion of conflict of interest, right now, Section 2 says that personal interest does not target interest in a matter of a general business decision affecting the public office holder being part of a vast category of individuals. One witness told us that according to that definition, the Prime Minister would not have to recuse himself in 99% of decisions. And even the Ethics Commissioner said the same thing when I was asking for an answer as to how we could increase standards. And I'm sure you'll agree with me that you have a politician's profile that has nothing to do with the profile of a politician that was part of revising the Act in 2013. I'd like to hear what you have to say about that. Do we have to extend the definition? Do we have to broaden it? I have other examples that I can give you. Again, from the point of view that we must make sure that citizens have trust in our democratic institutions.
I think at a very high level, I agree with you. I think that the rule of general application is one where it is very easy for people of means who are sitting in Parliament to get an even greater benefit. So, and I will make this example up, like someone who has $1 billion wealth fund, and they vote on a capital gains tax that would apply to everyone, and that change drew that tax liability down. That would be a very material advantage, but it applies to everyone. Now, the problem with the position that you're advancing is, well, if we don't have a general application rule, will parliamentarians ever be able to vote on anything? Where do we draw this line between what is something that is in front of Parliament and is important for the country to keep going, like, and we could get into NAFTA, or sorry, CUSMA or USMACA, depending on what you call it. Like, there are so many other things that an individual's past performance or past experience is going to have an impact on. It's very difficult to narrow the rule of general application. So again, like, I would invite you to make a suggestion and say, here is the proposal that I would make.
In the example raised just a few minutes ago, Parliament passed a law on a minimum global tax, and that meant that multinationals would have to pay at least 15%. During the G7 meeting in June, the Prime Minister announced that income earned by U.S. subsidiaries would be exempt. And he made that decision. 7 months earlier, the PM, who was Mark Carney, an individual who was running Brookfield, moved his company and the tax residence of his company to New York. So even if his decision to exempt active companies in Canada and being domiciled in the U.S. was a general measure, it seemed to be custom-made for Brookfield. So perhaps a Canadian taxpayer could benefit from this, but you can't be blind to the fact that even if it wasn't in his blind trust, you know, how much was it going to increase his fortune? He knows that it's going to increase his fortune, even if he doesn't know by how much.
Dit là,
So what I'm saying seems to me to be something that should lead us to try to find a solution to this very unusual case, because it's the first, but that doesn't mean it's going to be the last. Aren't you worried, ethically speaking?
And the reason it doesn't is because when the Prime Minister made that decision, when the Prime Minister talked about that at the OECD, we were in the process of talking to Americans about our ongoing trade relationship with them.
ça c'est votre interprétation politique.
That's
Ça,
your
c'est votre-
political interpretation. I am not reading anything about why he did it. I know that his position led him to make this kind of decision in given situations, and in that respect, an anti-conflict of interest filter managed by an employee who's his chief of staff is insufficient. Do you agree with that?
Very quick response to Mr. Theriault.
Mr. Conacher made the same accusation about people who are beholden to the Prime Minister. I would just say, look at the last couple parliaments. We had all kinds of people who were, quote unquote, beholden to Prime Ministers who stood up to them, some in very famous situations.
Okay.
I don't share your concern.
Okay. Merci, Monsieur Theriault.